attendance this morning. Jamie just walked in with the numbers. We have 330 attendees, including 7 conference rooms. I don't know how big those conference rooms are, so that's just an estimate of the number of attendees that we have. I'm Gary Wickert. Many of you may have attended webinars that I've given in the past. I'm a partner with Matthiesen, Wickert, and Lehrer. And today I'm going to co-host this webinar with Brad Jean-Blanc, who's an attorney with Fire-Iser and Castbaum in the windy city of Chicago, practicing throughout Cook County. Brad, are you with us?
I am, Gary. Thank you.
Awesome. Brad is one of our local counsel and happens to be our local counsel who handles the busy northeastern sector of Illinois when it comes to auto subrogation. So he's no rookie to the subject matter we'll be talking about today. Brad's a graduate of John Marshall Law School, is a graduate of the University of Illinois at Urbana-Champaign. He's licensed to practice in all the Illinois courts, the district courts for the Northern District of Illinois, and is a member of several bar associations there. He's heavily practiced in, he's a litigator, but heavy practice in automobile insurance subrogation. He also handles construction negligence and premises liability matters, so he has a well-rounded view on everything. You may recall that we, back in 2012, gave an initial viewpoint of automobile insurance subrogation in all 50 states from a view from 35,000 feet, and this was an overview of auto subrogation throughout the country. It roughly mirrored our book, aptly named Automobile Insurance Subrogation in All 50 States. But then during that webinar, which was 2 hours, we took a poll and we asked for, there was some 600 attendees, and then we asked them to rate the top 10 states that they wanted to have covered. And those were Texas, Florida, California, New York, Illinois, Colorado, New Jersey, Arizona, Michigan, and Louisiana. So as you can tell, we're on number 5, Illinois. And the next webinar will be, in this auto series, will be on Colorado. There are several things that combine to make auto subrogation one of the more challenging areas of subrogation, and I know you wouldn't know it by handling it because I don't think people who handle this kind of work get the respect they need, but if you think about it, there's 51 different jurisdictions with 52 bodies of different law, including federal law. There's a mixture of fault and crazy no-fault states, which mix about as well as oil and water. This area of subrogation is a moving target. It changes constantly, like the weather. Cars are designed to travel. They travel interstate, and that brings into the equation by necessity a mixture of the laws and the application of the laws of 2 or more states. So this is the #1 question we get on our website. If you haven't been to our website, please visit it. There's a lot of subrogation materials and resources there, as well as a subrogation question feature, which allows you to submit a question of any type, as long as it relates to subrogation or the Green Bay Packers. And we answer those questions diligently and hopefully accurately. But the #1 question we get has to do with extraterritorial issues, cars traveling from one state to another state, and which law applies. So that's a big area of automobile insurance subrogation, and another reason why it is complicated. Also, this area of litigation is targeted for anti-subrogation efforts more than any other. Illinois is actually a very straightforward state when it comes to automobile subrogation, were it not for the efforts of the trial lawyers and some others to sort of dig into the subrogation rights of carriers, and we're going to be talking more about that in this webinar, and specifically Brad's going to cover a big section on that. So we are going to have a trivia question once again during this webinar at some point, and when you hear the trivia question, of course we're going to shut down the Google servers, but you respond with what you think is the right answer to Jamie, and Jamie will let me know as soon as she gets the first right answer, and that person gets a complimentary copy of the Automobile Insurance Subrogation book, which is actually a $400 product, and I actually didn't even know that until after the publisher put it on the website. So it's been said that spectacular achievements are always preceded by unspectacular preparation, and that's what this webinar is all about. I'm hoping that you won't say it was unspectacular when it's over, but receiving a big check you otherwise wouldn't have recovered while trying to subrogate an auto claim, PIP, Medpay, uninsured motorist, collision, what have you, is always something that's fairly spectacular. So let's get started. Just an overview of Illinois automobile insurance coverage basics. In Illinois, remember there's only 2 states that don't require liability coverage, but Illinois of course does. And it's a good thing they do. As of 2013, Illinois had 8,054,232 licensed drivers. 11 to 15% rather of those are uninsured. But Illinois recovers mandatory liability coverage in the amount of $20,000 for injury or death to one person and $40,000 for injury or death to more than one person. In addition, it requires minimum limits of $15,000 for property damage to others as a result of any one accident. And Illinois defines property damage as physical injury to tangible property or loss of use of tangible property. In addition, Illinois requires insurers to offer uninsured and underinsured motorist coverage. Section 143A-2 sets forth the general rule that no policy can be renewed or delivered in Illinois unless it provides uninsured motorist coverage equivalent to the liability coverage that contained in that policy, unless specifically rejected by the insured. So this offer has to be in a commercially reasonable, quote-unquote, manner, and the insurance agent must adequately explain the availability of that coverage. An insurance policy cannot provide coverage with limits that are lower than the liability coverage unless the insurer has obtained a signed rejection. And if the limits for liability coverage exceed the minimum amounts required by law, the coverage must provide the same higher coverage amounts unless there's a written election to specifically reject coverage in excess of those amounts. So the insured may not select uninsured motorist coverage limits that are higher than these limits, as I said, but in 2010, the Illinois Court of Appeals held that payments owing by an insurer under the uninsured motorist coverage of a policy may be reduced by amounts paid by the insurer as Medpay benefits or medical payments under the policy. So that complicates things a little bit. With regard to underinsured motorist coverage, this must also be offered in an amount equal to the total amount of the coverage provided under the policy. And uninsured coverage is activated in one of 3 ways in Illinois. Number 1, the third-party owner or driver has no insurance, no coverage whatsoever. Number 2, the third-party owner or driver has insurance in an amount that's less than the minimum statutory limits. Or number 3, the remaining limits of the third-party owner or driver's liability policy have been reduced by other settlements or judgments. Now, this will become important later on because, let's face it, as automobile subrogators, we are often at the bottom of the food chain. We're the least scary to the third-party carriers, and often they will want to get rid of other folks who are a little bit louder and a little bit more menacing than us. Illinois laws we'll discuss later on allows the first-come, first-served rule to be applied in such situations. So it's important when doing auto subro in Illinois that we be aggressive and that we be first to the feed trough. We'll get into more of that later. So once again, any benefit due under the terms of a UIM policy is reduced by any amounts recovered from the tortfeasor. With regard to medical payments, Medpay, these pay up to a certain amount for medical bills of the owner, the driver, or his passengers. Coverage is usually offered at a $5,000 limit, but you can get more. And the obligation of the Medpay carrier in Illinois runs separately and distinctly directly to the injured person rather than the person insured against liability in the policy. That means that Medpay carrier will usually pay benefits to the insured spouse, a relative, a family member of the insured, or even a passenger in the vehicle. The injury must be incurred while any of the persons I just mentioned are occupying or operating an insured vehicle, or while walking as a pedestrian. And MedPay benefits are usually arbitrated, but sometimes not. Now, PIP payments, personal injury protection, one of the highlights of Illinois, and there are a few, is that it doesn't have no fault. And therefore, there is no PIP coverage required, and none of the PIP maze that we have to find our way through. In general, in Illinois, subrogation is treated as the same as a small minority of states do, including Missouri to the west. Illinois has established that a cause of action for personal injuries is not assignable. A lot of states do that to the west. Missouri does that, but unlike Missouri, which prohibits subrogation clauses in the policy because of this prohibition against assignment of a personal injury claim, Illinois doesn't look at it this way. They're actually a little more enlightened in Illinois when it comes to auto subrogation and personal injuries, because they don't look at subrogation as an assignment of a personal tort. To the contrary, Illinois says that subrogation works to secure contribution and indemnity, whereas assignment, on the other hand, transfers the whole claim. So while they don't allow an assignment of personal injury claims, they do allow subrogation of MedPay, and they do allow a policy to contain a subrogation clause for those benefits, which is important because, as we'll see later, that's the only type of MedPay subrogation we can have in Illinois. Just generally speaking, Illinois recognizes both equitable and contractual subrogation, despite its prohibition on assignment of personal injury claims, and it also allows for a right of reimbursement provided that the policy provides so. You can intervene into cases rather readily in Illinois, whereas in some states like New York and New Jersey, it's a little more difficult. Now we get to the first speed bump. The Healthcare Services Lien Act, Section 23/1 at SEC, is a relatively new creation, which was amended in 2012 and modified again in 2013. It's an act that repealed various other lien acts and dramatically affects auto subrogation in Illinois. It affects the made-whole doctrine. It affects and governs the common fund doctrine. It has a lot of different exclusions, and rather than get into it now, we're going to get into it when we discuss the actual subject of made whole and common fund, because those are the two key variables that you'll be dealing with when subrogating for auto damages in auto PI or property in Illinois. One last thing to mention about Illinois subro involves minors. In Illinois, your job is a little more complicated when minors are involved, because Illinois says that parents are primarily liable for a minor's medical expenses under the Illinois Family Expense Statute. Therefore, when you make a medical payment, it's to the financial benefits of the parents of the minor rather than the minor himself or herself, and therefore the minor is neither the beneficiary of the payments under the express terms of the insurance policy nor a third-party beneficiary, as one court has said. But I think what's important is that the cases that hold that you as the carrier can't subrogate, that this right belongs to the parents, it was a case that found that the minor's estate was not a third-party beneficiary of the insurance medical payments. Therefore, if we can convince the court that the minor's estate was a third-party beneficiary, and in that case there's no way to know how fervently, strenuously, and competently they argued that point, but if we can argue that the minor's estate is a third-party beneficiary, then we can perhaps recover for those benefits. Now, getting into Medpay subrogation in particular, it's recognized and upheld in Illinois. It's alive and well. A Medpay subrogation provision in the liability policy is enforced. A claim for reimbursement and or subrogation is allowed so long as it's provided for in the insurance policy. Now, the distinction here is that only your contractual right of subrogation no equitable rights will be allowed. Therefore, if your policy doesn't have your, let me just say you're going to live and die by the language of your Medpay Subrogation terms contained in the auto policy. So you're only going to be able to subrogate effectively if the policy provides for it. And once again, Medpay Subrogation has significantly been affected by the passage and amendment of the Healthcare Services Lien Act, and Brad will get into that in a little while. So policy terms control, I want to make a mention of something here that's a little afield of the law, but when you're subrogating for auto, I can't stress enough, and I think I see behind the curtains, like the doctor sees the bad medical results and the lawyer sees the catastrophes in life. I've been able to see some of the disasters that occur in the handling of subrogation files. And with regard to auto subrogation, the number one deficit, the number one shortcoming, the number one problem that needs to be addressed is a lack of adequate investigation. I'll just make this comment: get the police report if there is one. If there isn't one, make sure there isn't one. It contains all of the relevant information that's needed. This is Auto Subro 101, I know, but you'll be surprised how often it's not followed through with. Auto cases, I would say 65% of the cases I see involve no witnesses other than the two parties, and they always have conflicting stories as to what happened. Neither is ever at fault if you ask them. The other is always at fault if you ask the other person. So it's important to find out information, but when in statements, photographs, investigation, where did the accident occur? How many lanes were in each direction? What were the travel controls, the speed, the speed controls, the speed limits, travel direction, the cross streets? The place of impact on each vehicle is huge where there aren't witnesses. It is the third witness. Get pictures. Show debris on the road if at all possible. And I know you don't get out there when the accident occurs, but if there's photos, a lot of time you're insured or other witnesses will actually take photos on their cell phones and you don't know about it. I'm doing an article for Claims Journal, and I have a column in Claims Journal that deals with subrogation and has been quite well received, but I have an article in there coming up about the use of traffic cameras, how they can be introduced into evidence, how to get the photos, because the eye in the sky is larger than ever, as we know. Privacy is a huge concern across the country, in no small part due to the fact that you can't sneeze without having a video surveillance taken of it. So you can use this to your advantage. That article will go into some details on how to get those things. Who owned the vehicles? Who were the drivers? Anybody, make sure they were all properly licensed. Who were the passengers? Get names, addresses, relative names in case for witnesses when they disappear. They may be living in a mobile home and 2 years later they're gone. So all of these things are important and significant when handling auto subrogation. Uninsured motorist subrogation in Illinois, almost all policies in Illinois state that to the extent that the company makes a UM or UIM payment, it's subrogated to the rights of the insured to any proceed recovered from one legally responsible for the injury. In other words, the tortfeasor. Any such policy grants the insurer a valid right of subrogation. And this right of subrogation is also provided for in Illinois law, but it's more regulated. In Illinois, subrogation for an uninsured motorist policy can be against the uninsured motorist only. And this is, I'm sorry, against the underinsured motorist. It can be only against the tortfeasor who's underinsured. A party making a UM or UIM claim has responsibility under the law and under the policy to preserve the auto carrier's subrogation rights against the tortfeasor. So when a UIM subro claim is involved, the UIM carrier has the right to make a substituted payment or an advance payment in the amount of the available third-party limits to the insured that will thereafter allow him to be subrogated to the insured's rights against the underinsured motorist. This substituted payment program or opportunity is available and advisable only if, obviously, you determine that the third party has any assets or an ability to make a payment, which could include a good-paying job, and allow the opportunity to attach, seize, garnish, things of that nature. So the policy protects those subrogation rights by requiring the underinsured motorist to give the insurer notice of any tentative settlement with the underinsured motorist so that the insurer has the opportunity to advance the payment and protect its rights. So these policies have significant notice and consent requirements that are quite lengthy. Typically, they'll require an insured to notify the carrier in writing at least 30 days before entering into any settlement with the owner or operator of an uninsured vehicle. And then it also goes into some great detail explaining our right to recover payments against others. But as I mentioned, strangely in Illinois, a 1993 federal court decision provides that underinsured motorist subrogation is limited to monies recovered only from the underinsured motorist, not from related tortfeasors, or tortfeasors unrelated to the liability of that UIM motorist. Therefore, a UIM carrier is not subrogated, say, to any recovery from the manufacturer of a vehicle or faulty repairs or brake failure. The case is Ness versus Ford Motor Company, and the district court judge used tortured logic in that case to arrive at what he called an equitable result. In that case, Ness was rendered a quadriplegic in a single vehicle accident where he was the passenger in an underinsured vehicle driven by a friend. And Ness later sued Ford alleging crashworthiness, and there was a large recovery made, but the UIM carrier wasn't allowed to participate, which makes no sense at all. So Illinois is in the vast majority in this regard. And the substituted payment by the insurance company has to be made within 30 days under Section 5/143A-2. It requires a UIM carrier wishing to subrogate to make a substituted payment in the amount of the third-party liability limits within 30 days following receipt of the notice of settlement. And again, that notice of settlement was the one that I mentioned earlier, required under the terms of the policy. Collision subrogation is a huge, with 8 million vehicles and Chicago traffic, you can imagine that Brad is busy with a lot of our files. Collision subrogation is specifically provided for in Section 5/143B, and property subrogation involving damage to automobiles is also provided for under Illinois case law. So when there's an automobile accident due to the negligence of one party or the other, the proper measure of damages is quite liberal in Illinois, and we should take advantage of that. But the liberal measure of damages can also be a thorn in our side as subrogation professionals, and here's why. Measure of damages is the cost of repairs and the value of loss of use while the vehicle is being repaired. If the vehicle cannot be repaired, then the appropriate measure of damages is the difference between the market value before and after the accident. What complicates the matter is that diminution of value, the loss in value of a vehicle, even after a collision, is an element of damage that can haunt us, and I'll get to that in a second. But let's go back to loss of use, because in addition to the proper measure of damages, market value, loss of market value, repair, reasonable repair, you also, when a vehicle is damaged, can recover for the loss of use of a vehicle. And the plaintiff can recover, therefore, reasonable cost of repair, diminution in value, and his loss of use. But with regard to loss of use payments by the liability carrier, with regard to the loss of use payments by the liability carrier to damaged third parties, Illinois Administrative Code 919-80 has something to say about that. And no one ever looks here. No one ever looks in the regs. You know, a statute is passed by Congress or a state legislature, but a regulation is a detailed rule that outlines how statutes will be enforced, and sometimes even the legislative bodies don't have a role in passing those regulations. So under Illinois law, Section 919-80, it provides that in an automobile property damage liability claim in which liability is reasonably clear, the company shall pay for the reasonable and necessary costs in direct proportion to the extent of its liability incurred in the rental of another automobile vehicle, provided that the loss of use claim is submitted and substantiated. In those cases where the company pays a flat rental amount per day, week, or month, it must disclose to the claimant where the claimant can obtain a vehicle for the amount of his payment. In other words, a rental does not have to actually be made or paid for in order for a plaintiff to recover in tort for loss of use. Well, that right transfers over to you too. If your policy provides for rental, you do have the right to recover that, provided you follow the law. So to require the actual rental of a replacement vehicle, as some states do, Illinois appeals would just guarantee that most people will go out and get a rental vehicle even if they don't need one. So now diminution of value is sort of the wild card. Being familiar with this law is important because insureds will often claim diminution in value after they're made whole and say they aren't made whole. Because Illinois is a diminished value state, they can still claim the diminished value of the vehicle after the accident and after the repair. Illinois does have uninsured motorist coverage for diminished value, but there's also a statute which, section 143.24, which for a couple of years at least, was complicating things because it required the mandatory arbitration of physical damage subrogation claims. While this statute was in effect, and there's a reason I'm going to discuss it briefly, even though it's no longer in effect due to the case that's underneath it there, Interstate Bankers versus Hernandez, for collision subrogation involving amounts less than $2,500, the section 143.24D required mandatory arbitration between all carriers. But on December 18th, 2013, just before Christmas, this section was held unconstitutional by the Illinois Court of Appeals in the Hernandez case. It does not appear that the Illinois Supreme Court is going to rule on this decision, so it is law. Or what that means is that section 143.24 is not viable. In Hernandez, the plaintiff, Jose Mendoza Gonzalez, was involved in a car accident with this Hernandez guy in Chicago. And we're going to dismiss that. And Hernandez was insured by a unique insurance company. Gonzalez and Interstate, as Gonzalez's subrogee, brought a subro suit. Hernandez filed a motion to dismiss pursuant to section 143.24, saying the case should be arbitrated. And the plaintiff, in that case, Interstate Bankers Casualty Company, argued that section 143.24 was unconstitutional because it deprived them of their constitutional right to trial by jury in a negligence action. Now, there's some debate as to whether or not this was a boon or a bust for subrogation professionals, because it allowed a fast track for some of these arbitration for these physical damage claims that now have to be litigated in the busy Illinois courts. But it was actually an insurance company that got it dismissed. And so while the statute is no longer in effect, I did address it briefly just because it's likely to be a model for future legislation both here and in other states. I do mention also that, that section 919-80, the administrative code, remember that reg we talked about, it governs appropriate claim practices. I mention it because it's good for us as auto subrogation professionals to have every advantage possible. And that includes being familiar with tools that we can use to make our $2,300 fender bender subrogation claims more menacing. If I had a $6 million paraplegic claim, the insurance company on the other side would pay a lot of attention to it. But when you tell them you have $2,300 in damage, we all know that that doesn't really do anything other than cause them to yawn. But there are some things in Illinois we can do, and 919-80 requires certain things. It prevents unreasonable delays in responding to claims. All companies have to report unreasonable delay findings by a court of law to the director within 30 days. It requires 40 days to respond to automobile collision claims, 60 days for automobile property damage liability claims. And for total loss vehicle claims, there's a whole bunch of requirements in there that I won't go into, but it's good to know that that stuff is available for us. Well, I'll also discuss later offer of settlement and offer of judgment statutes and whether those are available to us in regard to whether or not it's of some advantage to us. Now we're going to get into made whole and some other areas that are really the meat of subrogation in Illinois. And I'm going to have Brad address some of these things. Brad, you want to take it from here?
Sure. Thank you, Gary. Like Gary said earlier, I'm local counsel for Matthiesen, Wickert, Lehrer in Chicago, Illinois. I've been working with Gary's office for about 5 years. So I see this stuff on a pretty regular basis, especially these amendments to the Healthcare Services Lien Act. So that's something we always need to be mindful of. But going straight to the general rule of the made whole doctrine, which is number 9 on the PowerPoint, the general doctrine is that there's no recovery for a subrogee, so the insurance carrier, until the injured party has been fully compensated. And that's regardless of any contractual language found in the insurance policy. Now, Illinois in the common law didn't follow this doctrine. There's a Gibson case back in the early 90s that says an insurance contract can allow the insurance subrogee to recover his entire interest, regardless of whether or not the injured party is fully compensated for their injuries and or their property damage. But now in Illinois, in 2013, the Illinois legislature, they passed amendments to the Healthcare Services Lien Act, and that's 770 ILCS 23/50. Now, this section is if a subrogation claim or other right of reimbursement claim that arises out of the payment of medical expenses or other benefits, so this typically only applies to med payments, exists within respect to a claim for personal injury or death, and the personal injury or death estate's claimant's recovery is diminished by his or her comparative fault or by reason of uncollectability of the full value of the claim. So what you're looking at is if a personal injury claimant, you're insured, is found to have been 20% at fault, then your Medpay subro interest is also going to be reduced by that 20%. So it's going to keep them from being made whole, and it's going to keep you from recovering your entire interest. So that's just another speed bump that Illinois puts in front of auto subro carriers. This does apply to reimbursement claims. You do need to have, as MedPay, you have to have contractual language for med payments in your insurance policy. Therefore, it's only going to apply if that contractual provision is there. Also, it can also come in with equitable and contractual subrogation, but we can discuss that at a later point. I just want to get through some of these slides because I know we're running a bit short on time. The big deal, another speed bump, is the common fund doctrine, which is another limit to recovery of your subrogation interest. Now, generally, Illinois courts will automatically reduce a subrogation or a reimbursement interest by 1/3, and that's done because it's an equitable theory, and the theory is they want to compensate the attorney or the party who generated, quote-unquote, the fund. So if you have a $10,000 collision subrogation interest for the property damage, while the injured party is also bringing a $1 million personal injury claim, the theory is that the attorney for that injured party has gained you your $10,000 property damage claim. Therefore, you owe them that 1/3. Now, the Seventh Circuit holds a little bit different from the Illinois Supreme Court regarding common funds, at least in ERISA cases, which are typically found in federal court. The Seventh Circuit will disregard the common fund doctrine if there's explicit contract language in the ERISA plan that says the plan participant or the insured has agreed to take care of all attorney's fees, and the ERISA plan is not going to be handling those fees. So you have that. It's a slight difference, but it's a difference nonetheless. There are some defenses to the common fund doctrine. Back in the 80s and 90s, there was the unwilling recipient defense. All you would have to do is write a letter to the injured party or his attorney that you were going to try to collect your subro interest payments directly. That isn't really the case anymore. You really have to actively participate and meaningfully participate in the litigation, either by directly negotiating with the tortfeasor and or his insurance company, or intervening in the injured party's civil suit. which Gary alluded to earlier, is relatively easy to do, especially in workers' compensation arena, and also with MedPay and property damage subrogation interests. There's also a common fund issue when it comes to setting off your med payments if you're paying under your underinsured motorist policy provision. You can set the set off from the MedPay can also get eaten away by the common fund doctrine. It's determined that the attorney for the injured party who's making the underinsured motorist claim is still producing that fund even though it's from your own underinsured motorist policy. Therefore, he's entitled to that one-third reduction for attorney's fees. If we go to the economic loss doctrine, the next slide. So you have the economic loss doctrine, which is also known as the Mormon doctrine in Illinois because it's derived from a case Mormon. Imagine that. It bars economic loss in tort, and these economic losses are defined as repairs, replacements, or consequential loss of profits if there's no claim for personal injury or other property damage. There are exceptions to this Mormon doctrine. I would look at the sudden and dangerous occurrence exception and the sudden and calamitous event exception is kind of one and the same. They allow economic loss to be recovered in tort if there was a sudden and dangerous occurrence, such as a ceiling collapse. And even if the sudden or dangerous occurrence took place gradually over time, such as asbestos cases and or mold infestation cases, those have also been found. You can recover economic losses. Also, you're always welcome to recover economic loss in tort if it has to do with fraud or negligent misrepresentation. The negligent misrepresentation allows for economic losses if the defendant, the tortfeasor, is in the business of providing guidance for others in their business transactions. So it's a little different than intentional fraud versus negligent misrepresentation.
Brad, let me just also throw in here, obviously the economic loss doctrine applies broadly across the scope of insurance and subrogation, but specifically applies to auto subrogation because a very common type of loss we see is the 1989 Buick Regal, which was parked outside the apartment, which suddenly burst into flames. The vehicle is no longer under warranty, and it's worth $1,700, but you pay that claim, and then you want to subrogate against Buick or General Motors because you're quote-unquote expert, and it says that it was a defect of the product. So.
Yeah, you'd really have to go into breach of warranty or alternative theories for recovery on that as opposed to just a straight tort case. But yeah, you're absolutely right, Gary. You're absolutely right. We see that a lot in fires and other cases of that nature. So if we could move forward just for purposes of time, moving forward to the statute of limitations, it's pretty straightforward. Personal injury, MedPay, subrogation, you have 2 years because that's the same amount of time the injured party has. And then for property damage, at least in this case personal property damage, it would be 5 years. You want to be sure that if you've made med payments, you don't have to bring your property damage claim, but you need to get that MedPay claim on file in court before that statute of limitations runs. If you look down the road and you're 3.5 years past the date of the loss, you've made your property damage claim, but then look back and go, oh, I made $2,500 in med payments, you're probably going to be barred due to the statute of limitations having expired on the personal injury portion of your claim. Also, you have design, planning, construction of improvement to real property. I see that statute of limitations come up in my construction cases a lot. That's a 4-year statute of limitations. And then products liability, it's the 12-year statute of repose. There's really no statute of repose for personal injury or personal property cases. Illinois goes with the discovery rule, but that usually doesn't apply with auto subro cases because you know the date of the loss because it's a pretty sudden event. It's not something that nobody would have known about until 6, 7, 8 years later. So that's always something to keep in mind. When you have your claim, the insured brings you a claim, you pay out your claim, you need to diary the statute of limitations as soon as you know it. Make sure you've sent this case to counsel and make sure that they know the statute of limitations. Otherwise, you'd be barred from bringing any subrogation claim on your own, and that would not be a good thing. So moving to the next slide, which discusses the release of a tortfeasor by the insured. A lot of times, tortfeasors try to get out of having to pay a separate subrogation claim if they have already signed or paid the injured party, the insured, and had a general release signed. Now, the fraudulent concealment statute does provide that when a tortfeasor with full knowledge of an insured's subrogation rights settles with an insured, general release signed by an insured will not bar subrogation suit against the tortfeasor or its insurer. Now, an unlimited release could, but I think the thing to keep in mind on this slide is that you as the subrogation carrier, the insurance carrier with the subrogation interest, you need to notify the defendant, the tortfeasor, or his insurance company as soon as possible. Let him know of your subrogation interest, because once you do that, you are not barred from bringing a separate suit, even though the tortfeasor signed an unlimited release. So I think the thing to take from this is notify everybody as soon as you can of your interest, so it won't be affected at a later date if somebody decides to settle with your insured, your injured party. So then we get to after a subrogation claim has been successful. What do you do? What do you have to do regarding your insurance deductible? Now, the Illinois Insurance Code, which is 215 ILCS, and it's section 15143B, says that the carrier is subrogated to an insured's entire claim, and that includes the deductible. You also are required to include the deductible in the subrogation action for the insured. I do this a lot. I make phone calls to the insured. I write them letters. I tell them I'm filing this suit on behalf of your carrier. However, I'm also including your deductible in the suit. I will attempt to recover it. Now, once I recover anything, the carrier is then required to repay a pro rata share of that deductible to the insured out of the net recovery. Now, this net recovery subtracts from the amount recovered attorney's fees, my fees, collection fees, and other fees that were required and spent in the process of obtaining the settlement or obtaining the judgment. Things like administrative expenses are not deducted as part of that net recovery. They're just considered, like it says in the slide, the normal cost of doing business. Also, if you're being paid by a tortfeasor or a tortfeasor's insurance company by installments, the law requires you to reimburse your insured pro rata share of each installment. So they're getting money as you're getting money. It's just another way to protect the insured in the insurance code. So moving next to the collateral source rule. Generally, collateral source is evidence of other payments received from other people to an injured party are not typically admissible as evidence, and they're typically not available. Typically are available, rather. An injured party can recover all of medical payments for a PI action in an auto case, regardless of whether or not he received $5,000 in Medpay from his insurance company. Now, there is, of course, your subrogation reimbursement provision in the insurance policy that allows you to recover that from your injured party, but he's not barred from recovering it, except in medical malpractice cases where the Illinois Code of Civil Procedure restricts the collateral source rule, and it allows doctors and hospitals to reduce their judgment up to 50% of the judgment if they can show that third parties paid money to the injured party for their medical bills. However, this section specifically does not apply to the extent that there's a right of reimbursement, subrogation, or lien. So this generally won't apply to auto carriers who have made med payments pursuant to their policy. Also of note, definitely of note, is Section 22301, which is the settlement of claims. This statute, the Illinois legislature decided that we need to expedite settlements. So we need to make it a problem if defendants are dragging their feet, defendants' insurers are dragging their feet on getting payments out. So this requires a defendant or his insurance carrier to tender a release within 14 days of the settlement agreement. And then if no payments are provided by that defendant or his insurer within 21 days of an executed release, the injured party or you, the subrogee, can recover interest and go into court and get a judgment on the case rather than simply it being a settlement. So that is also good. Also of note, just for your interest and for your knowledge, if a court needs to approve a settlement, it's the burden of the injured party, the plaintiff, to produce a court order. There's no specific time frame, but it's a reasonable amount of time. You have to produce that to the defendant so then they can get you the release as soon as possible. Moving forward to slide 16, which is the sudden emergency doctrine, it's just good to know that a standard of care, at least as far as litigation is concerned, changes if there's a sudden emergency. Even though the tortfeasor may not have acted reasonable in normal circumstances, if he's trying to avoid an emergency, such as if he's trying to avoid an accident on an icy road, he's trying to avoid a deer, his standard of care changes to a reasonably prudent person under similar emergency circumstances. Although this person might not have swerved from lane to lane, under normal circumstances, he might have done so to avoid a deer, and therefore his standard of care changes, and it makes it a little more difficult to subrogate against such an occurrence. Moving forward to the seatbelt defense, Illinois does not have the seatbelt defense. Generally, it states that evidence of an injured party's failure to wear a seatbelt is admissible to show failure to mitigate damages. As such, the jury can assess only damages the plaintiff would have incurred rather, if he or she was wearing a seatbelt. Illinois doesn't follow this rule. It does allow failure to wear a seatbelt as evidence for other purposes, but not for purposes of an injured party's failure to mitigate damages. And moving ahead to bailments. Now, it's kind of confusing whether or not a bailment has actually occurred, and it's important to know if a bailment's occurred because then suddenly, as long as the property is in good condition, the presumption, there becomes a presumption of negligence by the bailee, the person who received the property. So simply parking your automobile in a city lot like we have every block here, that doesn't necessarily create a bailment. So there's still the same presumption that, and the same burden of proof on the plaintiff for proving that the defendant did something wrong. However, if you're using a valet parking attendant, he takes your keys, he takes your car, you don't know where your car is, there probably is going to be a bailment. Therefore, the burden is going to be on him to prove that he wasn't negligent rather. But if he can, then it starts over and the burden falls back on the plaintiff to proceed with evidence, just as in any normal negligence case. I apologize for rushing through some of those. If you have any questions, please feel free to email us. I know I was sort of rushing, so I would totally understand. But I'm going to send it back to Gary for the remainder of the webinar. Thank you.
All right, we've been talking about suing a negligent driver, making a cell phone call, reaching down under his seat or something, but we also want to look at targets of a person, say the owner. Now, in Illinois, unlike a few states, the owner is not automatically liable for the acts of the driver. A person may be liable for negligent entrustment, however, of a vehicle where that person entrusts an automobile to one whose incompetency, inexperience, or recklessness is known or should have been known. And what's important here is that this is one way in close call cases. If we can allege negligent entrustment, all of a sudden, guess what becomes relevant? The driving record of the defendant. And this is a tool we often use to get the driving record into evidence that might not otherwise be admitted. So an action for negligent entrustment can be for entrusting a vehicle to a faulty human, someone who is reckless. But it can also be entrusting a faulty vehicle to a competent human. So if you think about it, there's several different ways to get to negligent entrustment. And although Illinois courts once took issue with whether or not an automobile was a dangerous article, it now clearly is. I didn't do this during Brad's presentation because one of my tricks during jury trials is just as I'm doing my my direct of a witness, I'll pass something to the jury, evidence, photos, gruesome photos maybe even. And then while he's doing his cross-examination, they're all busy passing around these interesting things and not paying attention to him. So I didn't do this to Brad, but I'm going to do the trivia question now. And the winner of which is going to should email Jamie and will be entitled to get a complimentary copy of our book, Automobile Insurance Subrogation in all 50 states. And here's the question. Illinois is only one of 6 U.S. states with more than 8 million drivers. Name the other 5. Name the other 5. Illinois is number 6, and there are 5 states with more more licensed drivers than Illinois. So now that no one's going to be listening to me, I'll go on with the guest statute, which may be the most archaic element of automobile subrogation. By the way, most states do not have guest statutes. The guest statute says that a non-paying guest passenger in a vehicle may not sue the driver unless the accident was caused by willful and wanton misconduct. And you can see the reason for this rule is to avoid collusion. One of the things that makes Illinois interesting is that we have a plethora of non-standard insurers in Illinois. I wrote a claims journal article recently, and I called them substandard, and I got a tongue lashing and a bunch of comments that were online. But so that this is the nature of the non-standard insured. Often, you have more of a proclivity toward this sort of thing, but to avoid collusion, guest statutes set forth this rule. Note that most states have gotten rid of their guest statutes. They say, hey, that's evidence that will come into the case. There should be nothing to prevent a father from suing a son or a sister from suing a brother if they're injured as a result of the negligence of the other. Now, the family purpose, but in Illinois, the guest statute is found in Section 510-201. Now, the family purpose doctrine, this is another method used in some states to get to someone other than the driver, perhaps someone other than the person who caused the accident for any one of a number of reasons. But the family purpose doctrine says that the owner of the vehicle is responsible for damages when the vehicle is driven by a family member with or without the owner's permission. Unfortunately, this document isn't used in Illinois, but it is used in a lot of other states, so it's something to be aware of. Rental cars, loaners, vehicles, and test drivers. We represent a major U.S. auto manufacturer and all their dealerships, and a number of other transportation companies that deal with this sort of thing. And the rule in Illinois is when you have a test drive, when a customer test drives a vehicle, new or used, the dealer's garage policy is primary and the customer's personal auto policy is secondary. That's statutory. On the other hand, where you have a loaner situation, and there's a typo. Actually, it could be loaner, and it's L-O-A-N-E-R. The primary coverage is determined by the amount of the customer's liability coverage. If the customer has 100, 350 limits, the customer's policy is primary. If the customer doesn't have those limits, then the dealer's policy is primary. And this comes into play when you want to subrogate against a permissive user. In a lot of cases, our insureds will allow someone to take a rental car home while their vehicle is being repaired, or they'll do a test drive, and they'll want to subrogate against the guy who wrapped the new car around a telephone pole. And one complication, though, and this does get rather complicated and must be analyzed on a case-by-case basis, is when you're subrogating against a test driver or a loaner, one of the defenses that can be used is that you're subrogating against your own insured in violation of the anti-subrogation rule. There are exceptions to that, but just so you know that is an issue. We alluded to this earlier, but in Illinois, a liability carrier is under no obligation to place priorities in relation to the claims that present the greatest threat of liability for an excess judgment against the insured. In other words, they can settle specific claims if reasonable under the circumstances, i.e., first come, first served. Be the first to get served. Be the first to the trough. I see a lot of problems in this in states that have this first come, first served rule, where there's a claims department, and then it takes some months to get a claim over to the subrogation department where you're not wearing both hats. And I've had a lot of cases where the trough is dry. by the time that the subrogation claim actually got there. Dram shop liability. Dram shop liability is, it's interesting because in the states where people drink the most, the dram shop liability is the weakest. I'm in Wisconsin right now, and I can tell you that with more pubs and taverns per capita than any state in the union, we have an extremely strong tavern lobby. There is literally no dram shop liability here in Wisconsin. You cannot sue the owner of the tavern except for extremely limited circumstances. I ran for the Assembly in 2011. Although losing by 22 votes, I helped write some of the new tort reform legislation that involved alcohol because there were only 2 lawyers in the Wisconsin Assembly, neither of which practiced law. And I can tell you that in Illinois, the Liquor Control Act of 1934, which has been amended several times, provides that the seller of alcohol causing intoxication is liable for resulting injuries or damages. This liability is strict. They're automatically at fault. They must serve more than a negligible amount. The seller's negligence must cause the injury. So I could serve a guy till he can't see straight, and then he goes out and causes someone's injury, but the cause of the injury has nothing to do with him being impaired. That won't satisfy dram shop liability. There has to be active or constructive knowledge that a person will be consuming alcohol, and an intoxicated person cannot make a recovery on his own. Now, the interesting thing is that although you have this strict liability for the seller of alcohol, Illinois has caps on damages. These caps, it's like it's a moving target. They change every year. As of 2013, I don't know if the 2014 numbers are out, but the cap, and listen to this, is for personal injury $64,057. For property damage, listen to this, the cap is $64,057. What does this mean for us? It means that dram shop liability might be a viable means of recovering property damage in the appropriate case, unless you're driving an extremely expensive car. But in a personal injury case, the trial lawyers are hopping mad that these limits are in place. So that's another option. As I mentioned, we want to take advantage of every opportunity that we have. I'm going to see if Jamie has the winner of our trivia question, and if so, I will announce that shortly. And the answer is yes. Congratulations to, why do I have to pick? Oh, we have a tie. Stephanie Milligan with AAA in Texas and Callie Byrne with Central Insurance. First of all, thanks both for being on here. We've never had this before, a tie. Okay, well, they each get a book. All right, we'll send you each a book. Thanks for playing along, and thanks for being the fastest typists and the quickest users of Google. I want to thank everyone for attending. The next seminar that we're going to be doing will be the auto seminar will be on Colorado. Jamie does not have a confirmation on the next seminar. Matthiesen, Wickert, and Lehrer will be providing, but that will be announced shortly in our newsletter. If you're not a member of the newsletter, let Jamie know. I want a special thanks to Brad. Brad, thanks for doing this with us. I think he did an awesome job of keeping stuff within an hour. It's not always easy, but my object, I'm sorry, go ahead.
Oh, I just said, no, it's not.
But our object is always to get everyone in and out within an hour, and I think we're almost there. I do have a couple questions. I'm going to answer most of these questions. Brad and I will via email. One quick question here is, we've had some success, and this is Margaret in San Diego. We've had some success forcing liability carriers to settle smaller property subro claims in states where they have offers of settlement statutes. Does Illinois have anything like this? Sadly, no. To my knowledge, every other state has a provision for an offer of judgment except Illinois. And what I mean by that is it gives you some leverage. You can say, I have a $5,200 claim. I'll take $5,100 if paid within the next 14 days. If they don't pay it, and you get a judgment for $52, they will owe you either attorney's fees or interest or costs, or every state's law is different. But as you can see, it gives you some additional leverage that Illinois does not give you. There's another question here. Brad, I'll let you handle this one here. It looks like that you talked about this.
Sure.
Tom in Chicago said, yeah, does the Healthcare Services Lien Act limit recovery to auto MedPay insurers in the same way as medical providers? I don't recall if you answered that or not, but I'll let you handle that real quick.
You know, it doesn't. The new amendments to the Healthcare Services Lien Act, those are specifically for subrogation lien holders, and it gets diminished in proportion with the comparative fault of the injured party and or the uncollectability of the judgment. That goes down just the same percentage as comparative fault will be found. However, providers and professionals, healthcare professionals, if they have a lien on the file, they're still entitled to their entire thing. However, there's certain percentages that they're capped at. Now, they can always go, because they have a debtor-creditor relationship with the injured party, they can always go try to recoup the rest of their medical bills at a later time. But as far as what they can attach their lien to, as far as a judgment or settlement is concerned, they just go with a specific percentage. I believe it's 20% for providers, 20% for professionals. The subro interest, it's 100%, but it gets diminished by any comparative fault of the insured or the uncollectability of any judgment. So it's sort of different there. It's kind of the legislature sort of snuck in that new amendment into an act that really doesn't typically apply to normal subrogation efforts, but they did it, and now we have to follow it.
All right. I neglected to provide you with the answer of the trivia question, and the answer is that the 5 states with more licensed drivers than Illinois are California, and we've done that webinar already. Texas, we've done that webinar already. Florida, we've done that webinar already. New York, we've done that webinar already. And Pennsylvania, which isn't in the top 10 of states that were to be covered in this auto subro webinar series. So California, Texas, Florida, New York, Pennsylvania, and then Illinois, with Ohio coming after that. But I will tell you that if you want to revisit any of these webinars for any of the states I've just mentioned, or the overall $35,000 view flyover webinar, which is the 2-hour, you can visit our website and see any of these webinars rebroadcast for free at any time you'd like. So I thank you for attending. We will get to all of the questions, and I see there's a couple coming in as we speak. Thank you for attending with us, and think subrogation. Have a great day. Bye-bye.